So hi, I'm Mark. Rather than the dry stock bio introduction, maybe I'll share with the group a few things that most of you, maybe none of you, know about me. Let's see. During the summer of my 8th grade, my mom and dad decided to send me and my best friend in life up to the Yukon territories to spend 3 months with a man who lived in the middle of nowhere, whose purpose was to teach us how to live with nothing but the clothes on our back. And so my mom drove us to SeaTac, put us on an airplane. We flew into Canada, hopped onto a puddle jumper, got dropped off, I think up near Whitehorse, got picked up by a person we'd never met in our life, who held them out to be the person they were supposed to be. And he loaded us into a Datsun B210 that was rusting out on the sides, drove us into the remote reaches of the Yukon, pulled off the side of the highway. We hopped over the guardrail, hiked for about a day to a river, hopped in a canoe, paddled for probably 6 or 8 hours to a remote camp. And I spent several months up there learning survival skills. That was something my folks probably wouldn't do in today's day and age. A lot of risk involved. It all worked out well. I came back about 25 pounds lighter at a time in my life when I didn't have any weight to lose. So when they talk about formative years and experiences, that was one of them. Okay. So for purposes of today, I have a PowerPoint prepared. Carmen actually had a glimpse of it yesterday with the Kiwanis Club. And so I'm glad to present that, or I could just do a spoken program with the club and answer any questions folks might have about any topic. There are merits to both. And so I'll just throw it out to the group and hear your preference, or I can start on the PowerPoint. And then if we get derailed and head off down a rabbit hole, that's just fine as well.
I'd say go to the PowerPoint, Mark.
Okay. In that case, I'm going to share my screen here.
Oh my gosh. He shared the screen and now I can't.
What just happened? Hopefully folks can see a PowerPoint slide.
Yeah, we can see it.
We got it.
Okay, great. Wonderful. So this is a presentation I put together. I've opted to entitle it Tipping Point. For those of you who haven't read it, there's a book with that title that's a fascinating read. And I thought I'd just start by defining, according to Wikipedia, what the phrase tipping point is defined to mean in sociological terms. And so in sociology, a tipping point is a point in time when a group or many group members rapidly and dramatically changes its behavior by widely adopting a previously rare practice. And I felt this was apropos for the time in which we live, given everything that's happened in Washington state and really across the country and around the world over the last year. And so that's the genesis of the program title. There are 4 things I'm going to speak about today that have been probably the most impactful events, certainly in relation to the prosecutor's office and the coroner's office as well, although I think they probably have impacts on a variety of other disciplines as well. The first is the global pandemic. For those who haven't been paying attention, on March 11th, I think as we all know, the World Health Organization declared COVID-19 a global pandemic, and that was its first such designation since declaring the H1N1 influenza pandemic back in 2009. And as with many disciplines, the pandemic has worked hardship on the operation of the criminal justice system and basic notions of justice. On the one hand, we had a series of court orders that required suspension of jury trial practice through calendar year 2020, which is really problematic because the criminal justice system prior to the pandemic was not known as being a particularly efficient or fast-moving system. And the old adage, justice delayed is justice denied, has been uttered for years in connection with its operation. With the pandemic, it's operating slower than ever, and people's ability to advance their trial to a jury has been compromised as a result, based on legitimate considerations sounding in public health in light of the pandemic. In any case, that has resulted in a large backlog of cases within the Clallam County criminal justice system, and that's something that's occurring across the entire state and country as well. Like everybody, we've been required to mask up at times, use alternative means of appearing, usually the Zoom platform or perhaps Microsoft Teams. The judges have gone about having the courtrooms reconfigured, oftentimes at fairly significant expense and logistical challenge. And so that and more has plagued us over the course of the last year. And of course, we're in a posture now where, as recently as yesterday, largely due to the more transmissible Delta variant, we're seeing what some are characterizing as a fifth wave of COVID-19 activity. And so yesterday we had an rolling average on 14 days of 209 cases per 100,000, which places us into the high risk category. More concerning is that it's becoming remarkably close to the 216 cases per 100,000 that we had back in November, which was our all-time high in Clallam County. I will not be surprised at all if the CDC on the one hand, and or the Washington governor, and or the Department of Labor and Industries, or our county health officer feels that their hand is becoming forced based upon what's happening, and issues a series of directives that will throw us back into a more regulated environment. I see no reason why they shouldn't. If the scientific approach that was taken earlier was deemed to be the best option, probably we should be expecting that to recur. And so we may see some harsher limitations with respect to the restaurant industries, salons, limitations on gatherings, et cetera, et cetera. And so I think for purposes of our club's planning, especially in light of the fantastic discussion this morning, it's probably a good idea to keep that at the forefront of our mind, that we may need to be a little malleable in rolling with some of these regulations and retasking our resources to accomplish a particular purpose. The second topic I wanted to talk a little bit about is Washington's new approach to drug possession. And I'm not going to spend a lot of time on this because I previously spoke about it with the club. But folks will recall that back in February of this year, our state Supreme Court issued an opinion that fundamentally changed how Washington state approached simple possession of drugs as a crime. In particular, the High Court found that Washington's longstanding 5 decades old statute, which criminalized the simple possession of drugs at a felony level, was unconstitutional because it violated the due process rights of the accused. The reason the court found that is because in Washington state, under our longstanding statute, a person could be successfully prosecuted for possessing drugs, even if they didn't know that they had them on their person and the drugs did not belong to them. So the court wound up wrestling with some equities, ultimately for the first time in its history, and notwithstanding some prior appellate court jurisprudence that found that there was an implied mens rea element in the statute. The court found no such mens rea statute this time around, voided the statute, and that invited a parade of consequences, which I've talked about in past programs. That includes vacating many convictions across the state, reimbursing legal financial obligations, and at least in the immediate aftermath of the High Court's decision, we found ourselves adrift as a state, being the only one that had decriminalized drugs for all purposes. And so because of that, and some of the consternation and concerns that were expressed by policymakers, lawmakers, prosecutors, law enforcement, and others, the legislature did take action. And a couple of months after the High Court's decision, the state legislature passed Senate Bill 5476, and that is the current law in Washington with regards to drug possession. Under the new law, possession of drugs is no longer a felony offense. Instead, it's a misdemeanor. Under the new law, law enforcement will no longer arrest a person who is found in possession of methamphetamine or heroin or other drugs. Instead, they are obligated by operation of state law to refer that person not just once, but twice, that is in relation to the first two encounters, for a drug evaluation and assessment. One of the challenges that's been identified is that there is no follow-through or accountability with regard to the offender needing to actually seek the evaluation and follow through with treatment. It's all in the honor system. It's only after the third contact between law enforcement and an individual found in possession of drugs that they can be forwarded to the county prosecutor's office or the city attorney's office, as the case may be, for a criminal prosecution. But even then, under the new law, prosecutors are encouraged but not required to follow suit with law enforcement and refer the person for an evaluation and drug treatment with no follow through to ensure that they actually do so. In addition, the state legislature has notably appropriated a significant amount of money and directed that towards drug evaluation, treatment, and substance abuse related services. That amount was north of $82 million. And the state legislature also appropriated north of $86 million to help offset some of the system resource that needs to be directed towards dealing with essentially undoing thousands of convictions across the state of Washington going back 50 years for folks who had been convicted under the statute, which has now been deemed null and void. The third topic I wanted to speak a bit about is currently trending as probably one of the hottest topics, at least within the world of criminal justice, and it sounds in police reform. Everybody's heard of George Floyd, and I'll talk about his murder and tragic death in a moment. But what's been overshadowed, I think, based on how the press has reported on police reform is the history of it. And so I wanted to provide a bit more context to make sure that that wasn't lost as part of the story, because it's very important. Back in 2015, the U.S. Department of Justice issued a final report from what was called the 21st Century Task Force on Policing. It's important to note that the reason for which this task force was convened in the first place was because there had been events that had occurred around the country that had raised questions regarding whether the police discipline should be looked at more carefully from a public policy perspective based on changes that had occurred in time, in the behavior of society, and at public policy. Notably, the task force report recommended clear and comprehensive policies regarding the use of force, training on the importance of de-escalation, crisis intervention, and mental health, the provision of first aid, and also recommended external and independent investigations in officer-involved shootings that resulted in either injury or death. And if all of this sounds familiar now, it should, because again, it's been trending in the press more or less on a daily basis for the last almost a year at this point. Following those events in 2015, if you fast forward to November of 2018, folks may recall that in Washington, Initiative 940 was passed by Washington state voters. And in 2019, the Washington state legislature passed Senate House Bill 1064, which in essence incorporated the recommendations that had been brought forward through Initiative 940. Those recommendations were codified by the legislature in the Washington Administrative Code, specifically in developing a required process that would need to play out every time law enforcement officers used force that resulted in death, substantial bodily harm, or great bodily harm. And so the requirement of the WAC following the actions of the legislature in 2019 required that every time a law enforcement officer laid hands on an individual and that resulted in, for example, great bodily harm or substantial injury, or deployed a taser or a firearm, there would need to be what's called an independent investigation conducted surrounding that officer's use of force. This would be designed to ensure that their use of force complied with departmental policy, didn't violate the state's criminal code, and was conducted in a very transparent fashion. The reason being, it was believed that more transparent review of officer use of force would increase confidence in the law enforcement discipline across the state. More recently, on May 25th of last year, George Floyd, a 46-year-old Black man, was murdered in Minneapolis while being arrested on suspicion of using a counterfeit $20 bill. And this is the event that really starts as the genesis of law enforcement reform in relation to the much of the reporting that we see in the newspapers nowadays. But again, it actually followed years worth of work in relation to the subject matter. George Floyd's death sparked a nationwide reckoning on race, policing, and officer-involved use of force. And in Washington state, while the legislature at the start of the last session was focusing on two law enforcement reform bills and having a pretty seasoned, reasoned discussion regarding the pros and cons of those two reforms, they were paying adequate attention to what we call the fiscal note, that is, whether or not any changes in law designed to reform law enforcement and policing might come at a financial cost. With the death of George Floyd, what we saw was those two reforms blossom into something more like a dozen. Time passed, was not a friend to the legislature. There was quite a bit of lobbying and advocacy that occurred. Law enforcement's voice was not assigned the same level of weight that we've seen in past sessions. And what came out of this exercise on July 25th of this year was a series of new police reforms that took effect in Washington state. Backers of these reforms hoped that the new measures will improve policing in the state, reduce the use of deadly force, and ensure that when deadly encounters do occur, that investigations are thorough, independent, and transparent. Critics of the reforms have raised and expressed concerns about how the measures could endanger the lives of law enforcement officers and compromise the fundamentals of public safety across the state of Washington. And last but not least, the fourth item, which I think is more important at the local level, is a recent development that occurred in relation to mental health court. And I'm pleased to report that following quite a bit of work and lobbying effort at the local level, we have now received a funding appropriation from the Board of Commissioners, and one that did not require any new taxes or assessments to the traveling public. Instead, there was monies available in an existing county fund that had been directed towards this program. And with Judge Newport, myself, the public defender, and a number of folks from the local medical community, including supporters within the hospital at OMC, Forks Hospital, Peninsula Behavioral Health, West End Outreach, Known, and others, we have quite a bit of support that's been brought forward to make this project go live by the end of this calendar year. I think this is going to be a bit of an experiment, admittedly, but a one that I think is going to be quite successful. And I think this is going to provide a tool to the criminal justice system that's been lacking for years in Clallam County, and that will allow us to get a better handle on a bandwidth of offenders who have been coming through the system time and time again, being prosecuted over and over again, with no tangible result coming out of it by way of a change in behavior. And so as the program goes live, I'll report more on it to the club and to the community, but we are on track to hopefully have our first participant or set of participants petition into the program by not later than the end of this calendar year. And so with that, I'm going to go ahead and stop screen sharing. and just open the floor to questions. Again, we've talked about 4 items: the pandemic, Washington's new approach to drug reform, or possession rather, and some reforms that have occurred in relation to that, police reform, and last but not least, mental health court. And those are probably the 4 most impactful things that we've seen develop within the disciplines in relation to which I work on a daily basis over the last year.
Could you talk a bit about how the police reform stuff would affect our local city and county policing agencies? Because my impression was they had already enacted many of the reforms that are in those bills, and I'm not always sure they get credit for that if it's correct that what I just said.
Yes, Laurel, that's a great question. Thank you for asking. And it really raises 2 points. On the one hand, our local law enforcement, well, actually, let me go back a step. Washington State, through the passage of Initiative 940 and the Washington Administrative Code provision that was adopted by the legislature in 2019, was well ahead of the national curve in relation to police reform. That's something that has been lost as part of the story, but Washington has always been out front as a progressive state in relation to policing. The changes that were required by Initiative 940 and the Administrative Code were never really given an opportunity to stand on their own 2 legs. Instead, events transpired with George Floyd, and that overshadowed any progress we'd made and prompted the legislature to jump back into action in passing even more reforms before we gave the former ones a chance to go on their own. As to the second part of your question, our law enforcement locally did take action to comply with the Administrative Code provision requirements that were adopted in 2019. Again, we haven't had an opportunity yet for an independent investigation team exercise to occur because we haven't had a scenario that has warranted that yet. The latest raft of law enforcement reforms are going to impact our local law enforcement heavily. While there's quite a bit of disagreement regarding the full scope and impact of the reforms in the world of law enforcement, in the world of prosecutors and municipal attorneys, everybody can agree that there are impacts and they are profound. And unfortunately, there's no answers forthcoming that are clarifying what exactly is the impact of the new law. I would characterize it as being the case that up until Sunday, July 25th, Washington State was a proponent from a policy level of proactive policing. That is, when somebody called 911 and called for the police, law enforcement could show up and take action to intervene and head off a tragedy or avert a calamity, or they could mitigate otherwise poor outcomes. As a result of the legislative reforms, we have really crossed the Rubicon, and now law enforcement is really required to be much more reactive in how it does business. And so unfortunately, what that means is that while law enforcement can still show up, there's nothing in the new law that says it can't do that. While it can be physically present on scene, the rules of engagement have so changed that they need to be very careful as a discipline in deciding whether they have the ability to do anything more than talk with an individual. The act of laying hands on a human being has become an extraordinarily high liability exercise, not just for the municipality involved, the department, but also for the individual officer and their family. The officer can be decertified. Their law enforcement and policing career can be ended immediately. If a panel out of the King County I-5 corridor determines in hindsight that they did not use the least amount of force that was appropriate under the circumstances. And so this has had a very chilling effect on the law enforcement discipline. It has negatively impacted morale. It has already, as of last Friday, resulted in some significant challenges at the local level. We had probably what I would characterize as a perfect storm situation that developed late last Friday afternoon that involved an individual who was needing to be picked up in connection with an Involuntary Treatment Act proceeding. The Involuntary Treatment Act is the act at law that allows for a person to be involuntarily committed when they're so ill that they're presenting as a danger to themselves or others. Law enforcement responded to a situation, as they always have, but found themselves in an odd posture where they were not able to lay hands on the individual who was uncooperative to make the situation safe so that first responders could bring that person to OMC and start the commitment process. And this has resulted in questions at the local level. There's been calls to the governor's office, the attorney general's office, our state representatives, our state senator, with an impassioned plea to fix this. Our hope is that best case scenario, the legislature will convene a special session early in 2022 and make some surgical tweaks to the raft of law enforcement reform and at least fix some of the more obvious, I think, unintended consequences that have attached based on the language of the new laws.
Mark, you know I have to butt in because I saw the whole thing unfold outside of my window for a very painful 4 hours last Friday. This person, it did not belong in law enforcement. And because of these laws, that person then ended up having to go through the criminal justice system instead of letting our crisis responders, who were the only ones allowed to involuntarily take somebody and get them mental health services. It was a tragedy. There were a lot of tears in the agency that day.
And it was, I would thank you, Rebecca, first and foremost. It was, it's the scenario that no jurisdiction wants to see happen, especially so quickly following the implementation of these new laws. And one of the things we're doing at the local level in the aftermath of the event that Rebecca and I have just spoken to is establishing what I would characterize as an after-action debrief group comprised of local law enforcement, mental health representatives from the hospital, and others. And what we're going to do is essentially conduct a debrief on a case-by-case basis as situations occur that call into question the role refinement of different disciplines, how we can best work together to seamlessly accomplish a required outcome without exposing any particular entity to unreasonable liability in the process. Again, I think what's really going to need to happen is that there's going to need to be some additional address of the new reforms by the legislature at a minimum in relation to Involuntary Treatment Act proceedings to make clear that, in the event law enforcement need to provide assistance, they can in those situations. Otherwise, they can't be expected to wade in and provide the same level of support that they have traditionally to first responders and mental health providers in relation to having a person brought into a condition where they can be further evaluated or introduced into the commitment process. But it's, in a word, it's a mess right now. And I don't have any problems defending why I believe that. Thanks, Rebecca.
So we've reached the end of our meeting here. Mark, thanks as always. Great presentation. We always appreciate hearing from you.